So, Grania, the Planning and Development, Maritime and Valuation Amendment Act 2022 was signed into law on the 24th of July of this year. The new legislation includes measures to bring more homes into the long-term property market in rent pressure zones. How will this be achieved?
Yes, so the new legislation is effectively trying to manage short-term lets in rent pressure zones. The way that they're trying to manage this is that online platforms such as Airbnb will no longer be permitted to have short-term lets on their website unless the development has the relevant planning permission or the development is an exempted development. So an example of an exempted development is your principal place of residence, so effectively the home that you live in.
And on the subject of planning then, I know there are several amendments related to design options which seek to provide clarity following a recent High Court judgment in a planning-related judicial review case. What changes will these amendments bring?
Yeah, so that relates to a judgment by Mr. Justice Humphreys, which was released last year. And since then, there has been like a little bit of confusion as to the degree of flexibility that is available in a planning permission. So these changes in the legislation seek to bring clarification in that space. So a new procedure has been introduced where you can basically seek an opinion from the relevant planning authority whether the development can have flexibility encompassed within the planning permission. If the planning authority is of the view that flexibility can be ingrained within the planning permission, then this will be granted by way of condition if the development is consented.
So, substitute consent then. I know that the substitute consent process in Ireland has been in flux in recent years, with the added complexity of an applicant wishing to seek substitute consent, first having to apply to the relevant consenting authority for leave to apply for substitute consent. This new legislation seeks to amend the substitute consent process in Ireland. Can you please talk me through these changes?
Yes, so substitute consent has traditionally been quite an elongated process. So as you said, there's two stages. Stage one is leave to apply for substitute consent, and stage two is the substantive substitute consent procedure. That has been effectively meshed into one application. So now there's just one stage for substitute consent. There's also now an opportunity to apply for a simultaneous application. What this means is that you can apply for substitute consent and you can make a planning application at the same time.
Also, efforts have been made to limit the circumstances in which leave for judicial review will be granted. Can you tell me more about this?
Yes, so in Ireland, the threshold for leave to apply for a judicial review is actually quite low, and that has led to quite a backlog of planning judicial reviews within the courts. So this legislation again seeks to kind of assist in that area. So now, before you will be granted leave to apply for judicial review, you will have to have exhausted all other remedies, such as appeals, under the relevant planning legislation.
Finally, I know there are several changes made to the Maritime Area Planning Act 2021. Can you talk me through some of these, please?
Yes, so the Maritime Area Planning Act was enacted at the end of 2021, and most of that act actually has yet to be commenced. Notwithstanding that, this legislation also introduces a number of amendments to the Maritime Act. One of the interesting amendments is the introduction of a special enforcement notice. So this is a procedure that the MARA can initiate if they're of the view that there's a particular breach that is sufficiently serious that would warrant this kind of procedure. So non-compliance with a special enforcement notice can be more severe or more serious, and it can lead to your authorization, such as a MAC, being terminated.
And when will this new legislation come into force?
So as you mentioned, the Act was actually enacted at the end of July of this year, but many of the provisions have not yet been commenced, such as the flexibility provisions and the substitute consent amendments, and these will have to be commenced by way of commencement order.
Okay, thanks, Grania. Thanks for talking me through some of the changes introduced by this new legislation.